Hey everybody, Greg Lake here, attorney and co-founder and CEO of TheoConnect.com. Today I'm here to talk about a new court filing that has been filed here recently in the Arizona Yage case in Arizona District Court. Just for the short here is that the DEA and the Arizona Yage have indicated to the district court in Arizona that settlement negotiations could be possible as far as Arizona Yage's claim that they are exempt from the Controlled Substances Act under the Federal Religious Freedom and Restoration Act. So it remains to be seen whether this will be fruitful or even possible. But, it does signal potentially a direction change for the DEA in how they handle enforcement of the Controlled Substances Act against sincere ayahuasca practitioners. So a little bit of history and background. The Arizona Yage filed suit against the federal government, the DEA included, back in 2021. The case also included other entities like the Vine of Light Church, but also the North American Association of Visionary Churches. Not long after suit was filed, the government targeted the leader of the Vine of Light Church, Clay Villanueva, and there was a lot of drama that went back and forth there. Mr. Villanueva, who was suffering from cancer at the time, was picked up at the Los Angeles International Airport. During the process from filing suit until that point, the district attorney back in Maricopa County in Arizona had filed formal charges and had a grand jury indictment against Mr. Villanueva, of which he was not aware. So he got hemmed up in the Los Angeles International Airport and taken to jail. There was some court filings done, and eventually he was released. But unfortunately, Mr. Villanueva passed away not too long after he was released from incarceration. All my prayers and blessings to his family. I want to say thank you to Mr. Villanueva for your bravery and standing up to fight for your right, which, if it turns out good, will incidentally benefit many, many, many people in this country. So thank you, Mr. Villanueva's family. I want to honor his life here today. So again, I said in addition to the Vine of Light Church, there was also the North American Association of Visionary Churches was originally named as a plaintiff in the suit. Now, this is an organization, I believe, of 10 different ayahuasca churches. Not sure the disbursement geographically of where these churches are from, but they all banded together to form a separate nonprofit called the North American Association of Visionary Churches. And so they entered the litigation and also asserted rights and claims under the Federal Religious Freedom and Restoration Act, basically requesting that the court give them or make the DEA work with them to acquire a master DEA license wherein the master organization, the North American Association of Visionary Churches, would be able to import ayahuasca in bulk and then dispense it or distribute it to all of its member churches in accordance with their needs. Therefore, that would vitiate the need of every individual ayahuasca church under its umbrella to individually sue the federal government. Basically, the master organization was planning on suing the DEA and then getting this master license on behalf of all of its member churches. So the NAAVC's claim was also attacked procedurally by the federal government. The judge ruled that he did not believe that the NAAVC had standing to sue under the Religious Freedom and Restoration Act. And so NAAVC is now seeking an appeal to the Ninth Circuit of that decision. So there still is a lot that remains to be seen as far as whether they do have a valid claim and standing under the Religious Freedom and Restoration Act and whether they are able to assert and acquire a DEA master license. So that would be very interesting. If that is so, if they do acquire this master license that they seek to distribute to all of its member organizations, then that signals the need for more ayahuasca churches in the country to band together to assert similar claims. Obviously, when those churches can pull resources together for legal fees and expenses, it makes it much more doable and possible to assert the rights of many, many, many religious practitioners in the country. So now that the NAAVC is out, unfortunately, when Mr. Villanueva died, the Church of Divine of Light, and I might have butchered that, they also dropped out of the litigation subsequent to his untimely death. So now there remains Arizona Yage Assembly against the federal government on just a straight up Religious Freedom and Restoration Act claim, where the judge will have to decide, A, whether indeed Arizona Yage Assembly are sincere religious practitioners. If so, if their religious practice has been substantially burdened, and then if so, whether the federal government has a compelling governmental interest in enforcing the Controlled Substances Act against the Arizona Yage Assembly. I'm sure as many people are aware, the U.S. Supreme Court has okayed these types of religious practices previously in the UDV case of 2006, and then in 2009, the Oregon District Court okayed the same religious practices that related to the Santo Daime, and declared both of them exempt from the Controlled Substances Act and required that the federal government work with them to import, track, and manage their sacrament. So now the kind of heart of this video is that there is recently, last month, a court filing made by Arizona Yage Assembly and the federal government asking the court to stay the case pending settlement negotiations. Now I say that because the pleading doesn't tell judge or doesn't say to the court that they've actually agreed to necessarily enter into negotiations, but they are having preliminary talks about doing so, basically deciding on a framework of how that will proceed, and then also see if it's feasible. The parties are supposed to report back to the court by July 26th to say whether this will be a possibility or not. So stay tuned. I will keep up with those court pleadings as they are published. So let's talk for just a minute about the DEA's history of dealing with and negotiating with ayahuasca practitioners. So obviously in the UDV and the Santo Daime cases, there was a no-go. There was no negotiation. Both of those claimants had to file suit. The UDV had to fight theirs all the way up to the Supreme Court. Fortunately for the Santo Daime, after a quick appeal to the Ninth Circuit, the government dropped it at that point. And so the Arizona Yage Assembly case really represents one of the first fronts where we see the DEA actually potentially reaching out to negotiate with religious practitioners in good faith. Many also watching this video are aware of the SoulQuest case in Florida. So, you know, with SoulQuest, like a few other religious practitioners, they had applied for the DEA's guidance process, which, in my opinion, is unconstitutional and not valid government policy on many, many different grounds. But anyways, the SoulQuest reached out and filed an application for exemption with the federal government, I assume in good faith. Now, the DEA failed to give them a response for, I believe, almost 3 years. And this is despite being prodded several times by SoulQuest attorney. So a little bit over a year or so ago, the SoulQuest actually filed suit against the government, just like the Arizona Yage did, seeking a ruling on their exemption status under the Federal Religious Freedom and Restoration Act. After that litigation proceeded for a bit, the government then, in that case, also reached out to SoulQuest and said, look, let's stay the case. You know, let us do our investigation, and we can probably settle this matter without having to go to a full-blown trial. So what did SoulQuest do? They trusted the federal government and let them finish their investigation. And what happened is that the DEA denied the exemption request by SoulQuest and filed the letter into the court record in the district court. Well, what happened then? Well, unfortunately, all right, so the best way I can explain this is that normally when the DEA makes a determination, okay, and granted, by statute, the DEA is really only over medical and research institutions, right? So when it makes a final ruling under Section 893, which is the Controlled Substances Act, as it relates to those types of entities, the decision is final and is only appealable to the U.S. Circuit Court. So theoretically, had the DEA ruled on SoulQuest exemption, you know, prior to them filing suit under normal circumstances, it would have only been appealable to the 11th Circuit. Now, here's the issue with it is that, you know, the DEA has no statutory authority over religious practitioners, right? Part of this RFRA analysis entails a determination that the claimants are indeed sincere religious practitioners. Quite clearly a determination that the DEA has no statutory or constitutional authority or ability to determine, right? The DEA, to the best of my knowledge, doesn't employ theologians. So anyways, but what ended up happening to SoulQuest is when they filed the denial letter, into the record. Now, let me say this. Let me back up for just 1 second. Is that part of a RFRA determination is also safety and diversion, right? So the court is going to look at whether there is an extreme or severe health risk to the members of the congregation, and B, whether the church is handling the substances in a manner that lends itself to the sacraments being diverted from religious to non-religious use. So obviously in the Soul Quest letter, which was filed in court, they said that not only do they think that Soul Quest is not sincere, but also believe that they're actually not practicing a religion. So obviously those are determinations that no one would agree that the DEA has authority to make. However, what the DEA did do was rule on particularly the diversion issue. So the DEA does have jurisdiction over diversion for preventing diversion of scheduled substances, right? So what the district court said is, look, because you let the DEA rule on this diversion issue, which they do have jurisdiction over per 893, district court no longer have jurisdiction. You're going to have to go get this settled with the 11th Circuit. So as of now, the Soul Quest case is in between being filed, the district court being filed in the 11th Circuit. So I'm hoping that the 11th Circuit will reach the merits of that case here before the end of the year. So what does this mean for the Arizona Yage? Well, what this means for the Arizona Yage is that if they are going to enter into settlement negotiations with the DEA, which by all means I hope this does come to fruition, they're going to have to be careful and not allow the DEA to make a ruling which could be perceived as a final determination under 893. And you might ask, well, that's part of the Arizona Yage's case, so how, if they enter into settlement negotiations with the DEA, are they going to avoid the DEA making that kind of determination? And let me back up for just 1 second. I and many other legal commentators do not believe that the Florida District Court got it right, that they should have retained jurisdiction anyways. But just assuming in arguendo that they were correct, I'm kind of applying that theory to what I'm about to say. So in order to prevent a situation like Soul Quest is, one, as a lawyer, I would make sure to determine to the best of my ability whether, the DEA is actually there to negotiate in good faith. Two, I would want to make sure that there are reasonable timelines and benchmarks set to keep the DEA on track and prevent them from further delaying the litigation like they did in Soul Quest. Because remember, not only did they not answer Soul Quest's petition, for exemption for about 3 years, once they stayed the case, it took over a year then for them to even issue a final determination. So as Arizona Yage's attorney, I would want to make sure that there are reasonable timelines and benchmarks set to where we're not delaying this litigation indefinitely, because it's very important that their client gets their determination under RFRA one way or another made in a timely manner. But three, and I think the most important, is that there needs to be some kind of stipulation and or agreement or both between the federal government and the Arizona Yage that any determination made during these settlement negotiations by the DEA does not constitute a final determination under Section 893. Again, there's a number of different ways to skin that cat, but if they want to avoid having to go straight to the Ninth Circuit or go up to the Ninth Circuit to determine it, they're going to need to give some assurances either by the court or by the council. I think the best thing to do here would be to file a stipulation into the record that the DEA, recognizes and waives its right to have any determination it makes be deemed a final determination. So, and that's probably the biggest one. Again, unfortunately, Soul Quest kind of got bamboozled into this, and granted, most legal commentators don't think that the district court got it right. So nothing to blame there on Soul Quest's attorney. In fact, they were trying to do what's right in order to save the taxpayers money and save Soul Quest money and do things amicably and not clog the court's docket. So that's kind of hopefully the same reasoning here in the Arizona Yage case. But, the big what if here is the DEA going to show up to negotiate in good faith? And B, are they going to be able to reach some type of preliminary agreement that whatever determination is made by the DEA is not a final determination under 893, thereby retaining jurisdiction in the district court. And again, in summary, I do think that this is a good sign. My gut tells me that the DEA this time around hopefully will enter into good faith negotiations with the Arizona Yage. I could see them working with and approving the Arizona Yage over SoulQuest. Not that I don't believe SoulQuest, are sincere religious practitioners, but there are some facts in the SoulQuest case which kind of makes it harder to prove up that aspect, but in my belief can be worked around, that aren't present in the Arizona Yage case. And so I'm thinking that those facts might tilt in the favor of the Arizona Yage in the sense that the DEA, there is a decent or good probability that the DEA would grant them an exemption outside of the judicial process. So again, this remains to be seen. I want to thank everybody for watching the video. I'm going to keep updates coming as this and other legal cases in this space progress. I want to thank everybody for coming again, supporting the social media. If you want to pre-register for Entheo Connect, please do so at the website. Again, we will be launching our first rendition, the Entheogenic Church and Service Provider Listing Platform on July 25th. If anybody has any questions or wants to reach out to me regarding the platform or the content of this video, feel free to contact me at george.lake@entheoconnect.com. Much love, everybody.